Alrighty, good morning, everybody. I hope you had a good night's rest. And I'm impressed. The first person I spoke to this morning on the webinar already said that she did her homework and watched the YouTube clip on the YouTube recording on Ubuntu. So it feels like this is going to be a fantastic day. Also, you guys entertained me through the evening because these are emails from you guys. Thank you. Ooh. Not on mute. Really not on mute. Lost it, my eardrum there. Ach, Jelle, please mute your mics. Okay, so you guys entertained me with like a bunch of emails. You kept me awake. Thank you. Otherwise, I would have just been awake and like bored, and then I would have done something like be on social media, read a sad article about somebody moaning about lockdown regulations, and I wouldn't have been in such a good mood. So thank you. I was thinking for today, I just want to deal with a few of the questions from last night, because very often I find if one person has a question, you're probably not the only one. So I do want to clarify a few of the things. It's not going to take me more than 10 minutes, but it's just going to wrap up yesterday completely in a little parcel with a ribbon and everything on it. So let me do that, deal with these questions. Then we know we're good and we can go into the actual eviction side of things. What I want to say already, before I forget, and while we're still all awake and after our first 3 coffees for the day, I spoke to Barbara this morning from LSSA, and we are talking about more webinars. It seems like you guys are enjoying this one, so thank you for finding my webinar helpful and entertaining. I'm really happy to hear that it adds value to your firms, because that's my point. That's the purpose of why I do what I do. I want to make sure that you guys can have value from the 2 hours, well, 5 hours that you are giving me, that I'm giving you more than 5 hours worth of billing back. So what we're going to do is we are going to host another webinar next month, potentially another one in August. I want to do one with exclusive focus on commercial, retail, industrial properties. So because this focus is only on residential, but every now and again I make some mention of commercial. We're going to do a full webinar on commercial properties and how we deal with those evictions, rental collections, everything right now. And then we will do another one, exclusive focus on Ubuntu and application of Ubuntu in eviction. So I'm super excited about that one. I've been nagging about for the past 5 years. I've been trying. Oh, somebody's not on mute. I've been nagging for about 5 years that I want to really push Ubuntu and the way we apply Ubuntu in evictions. And everybody always, when I say Ubuntu, just says, ach nee, Silna, what are you now busy with again? Like you are a new mission. And suddenly COVID opened the door for us to change the way we practice law. And I'm really excited to do that. So we haven't confirmed dates yet. Simply because my PA is working from home. So to try and get a date out of me currently is almost impossible. I barely know what I'm going to do after today's webinar. So I will confirm that with Barbara. So please keep an eye on LSSA's website. But also, as you know, you get your LSSA emails. So don't go and attend a boring webinar now about Excel skills or something silly like that. Save your webinar money for the ones that I'm going to do on evictions, on commercial, and then on Ubuntu. So I just wanted to give you guys a heads up so you don't say in 2 months, ach nee, still, no, you should have told us. Alrighty, and so let's just deal with a few questions. If I don't deal with your question right now, it's not because I don't love you. It's because you're getting special attention, and I'm going to reply to your emails, or I'll give you a call this afternoon. I have nothing else planned for this afternoon. Again, like I said, my PA is working from home today, so I can be like naughty. I'm like that kid whose teacher didn't pitch up for the day. So I'll give you guys a call and really just discuss what we have. But I had a question here. It's a very interesting thing, and now we give away that I'm really not 30 anymore. The question here is a very interesting one. So I'll give you the fact sheet very quickly. The fact sheet is tenants struggling to pay rent, obviously as a result of the COVID situation. But this has been happening since the 6th of March. So now already I'm like, okay, on the 6th of March, wasn't that the first day that we had like that first case in Durban? So we didn't even have COVID yet. It was like, we were still laughing at like Italy and Spain, like, you guys should do it proper, be like us. It was still in those days. But then there was a lot of decisions back and forth, commitments from this tenant to vacate or to pay rent or whatever. And now pretty much nothing is happening. And obviously this colleague's client is extremely frustrated. So frustrated clients, guys, I think right now is the moment we as attorneys need to appreciate and have a very high level of empathy with our clients. They are very frustrated, and the truth is, so are we. So we all frustrated, but again, as it goes, if you're the adult in the room, you have to be the adult in the room. If you're the attorney in the room, everybody expects you're not just the adult in the room, you're the adult with the answers in the room. And we all know we don't have the answers, but let's not like tell anybody right now. They're going to freak out completely, but appreciate that our clients are very frustrated. So how we're going to deal with this, obviously, answer as best as we can. So question is, what is my advice on this? How would I deal with a scenario like that? So if I currently sit with a landlord-tenant relationship where the tenant has made 1 million promises to pay, the tenant has signed AODs, the tenant has signed amendments to the agreements to repay the amounts that they currently can't pay, to use the deposit, to whatever they've agreed to, and the tenant is not keeping to that arrangement, my suggestion is definitely place the tenant on terms as you normally would. I would like to see that any arrangement that is made outside of the lease agreement is reduced to writing and signed by both parties. However, I think it is important to appreciate that a lot of our clients and tenants made arrangements with each other that they haven't reduced to writing. I get that's a problem, but I can't give a blanket answer per case. But like I said, you guys are welcome to give me a shout and ask me for just to actually not ask me for advice. Sometimes you just need to brainstorm with someone. So if there's something like that, remember I'm available for those things as well. You're welcome to ask me questions in future as well, because if an amendment to a lease agreement hasn't been reduced to writing and hasn't been signed by the parties, to prove that the tenant is in breach of that particular agreement is difficult, but let's look at the other side. To prove that there was an agreement to that effect is also pretty impossible. So I'm fine. It was tea, I promise. So something very important there is send a letter of demand and draw the tenant's version out in writing. It is easier to work from there once a few extra things are in writing. Then, so my suggestion is send a letter of demand. And then the question is it possible under the current regulations to have a warrant of ejectment issued at court but stayed? We understand that we are not able to send it to the sheriff to execute under the current regulations, but the idea is to be first in line when it's permitted. Okay, very important question, and I think this is sort of the crux of what we're going to talk about today. We are allowed to execute eviction orders, but you need a court order saying that you are allowed to execute now. So you have one of two options. Either on your eviction applications, your orders that were granted pre-lockdown, approach the court again now with a secondary application, asking the court for directives and orders surrounding execution of that order. You are allowed to approach the court and say, listen, I need to execute. Can I please execute this order? And the court will give you that order. The sheriffs are making their own rules currently. And I'm saying this with the necessary lack of respect that this deserves. because the regulations are clear that the sheriff is supposed to serve new proceedings, to execute on eviction orders where the court ordered that we can execute, and to do all the normal things that they are supposed to do. And the sheriffs and a lot of magistrate courts are basically making their own rules. They're like, no, thank you, we're still in level 4, and the rest of the country is like, Bookie, that's been like a month ago, we can move now. So it's very important, approach the court and get those orders. And I want to take it a step further. Don't try and complain to the sheriff's board if a sheriff doesn't want to do what they're supposed to. Bring an application to compel that sheriff, because you're doing all your colleagues in the area a favor. If you are in an area where you have an attorneys association, get your friends around the table and approach the court in one go against that particular sheriff, so we can get the sheriff starting to focus on doing what they're supposed to be doing. If you don't have an order ordering that an eviction warrant of ejectment can be executed, you can't, and the sheriff is well within their rights to say, no, we're not going to execute. So get your orders and make sure the sheriff does what they have to. My suggestion is, if you have to anyway bring an application to ask the court for authorization to execute an eviction order, my recommendation is, as a second pre, add the sheriff anyway as a respondent, just to give them notice, and ask the court as a second pre anyway to order the sheriff to execute that order. So then you don't have to reapproach the court again. I always say, while you're in court, ask for everything you want. Otherwise, we do it like piecemeal vibes, which doesn't work for anybody. And then the other questions are relatively easy. There were two around CPA. So the one was, let me just get them. So the one was just clarity again on why I am referring to Section 45C of the Rental Housing Act and saying that a landlord is allowed to cancel a lease agreement midterm, while the CPA clearly states that you can only, I'm sorry, I won't even lie, I've dropped my hot water bottle towards hot thingy. I'm cold. So now we all know what's happening here in Joburg. So very important thing on that, it's important to know that these two pieces of legislation aren't mutually exclusive. The CPA doesn't say a landlord is only entitled to cancel in terms of the CPA. So a landlord will always have the right, in terms of Section 45C of the Rental Housing Act, to cancel the lease agreement, even if the tenant is not in breach, provided, again, in terms of Section 45C, that provision is made mention of in the lease agreement, and that the reason for cancellation doesn't constitute an unfair practice. So it's not in a contradiction to the CPA in any way. And then there was another good question, Geraldine. I don't want to go into too much detail. I'm worried that we're going to then go into an hour's debate around it. But I'm happy to give you a call this afternoon as well. I will. Around the early cancellation penalty in terms of the CPA. So if a tenant cancels the lease agreement in terms of the CPA, then he is liable for a reasonable cancellation penalty. But that happens with regards to goods supplied, services provided, things like that. So Geraldine's question was centered around, does a penalty even fit into a lease agreement? And I will say this to you guys, because I'm probably going to throw this apple cart over in any moment now this year still. I agree with you completely, Geraldine, and it's been my sentiment for quite a long time, that a penalty can't even almost fit into the equation of a lease agreement. It doesn't make logical sense. I think most of you will agree with me, but remember, you're attorneys, so you guys get what I'm on about when I say a penalty and damages are so far apart, and somewhere with the CPA coming into play, the property industry decided, like, we are now going to claim a cancellation penalty. But it doesn't make logical or legal sense in the particular context of a lease agreement. So what I'm saying is, let's sit tight. There is already a few matters pending on clarification on this. Don't try too much now to try and convince all your clients about this. I promise. I am working on it. I am keeping a very close eye on what the tribunal is doing and what the courts are doing around this, because I personally don't believe that a penalty makes sense in any way, shape or form in a lease agreement. For the time being, my suggestion is use the terminology damages instead of penalty, and we are already going to force the law in the right direction with that. So I hope that makes sense, Geraldine, but I'll give you a shout this afternoon. Brilliant. So today we're actually going to do much less slideshow. I think yesterday you already saw I'm not the slideshow type. I hate a slideshow. I'm actively allergic to a slideshow, but on a webinar, it is a little easier. But what I want to do today, so today we're going to go into evictions. What does an eviction actually look like? How do we do it practically? How does it work? So I'm not going to bore you with too much substantive law. I think you've got it, but you need to understand practice. And I think this is why you are here. You want to know, what do we do when a client walks in and says, I have an illegal occupant, will you please evict him? So this is what we're going to do. So in true my true style, I don't stick to any rules in any way, shape or form. So I'm going to do this webinar the wrong way around. I'm going to start at the end and then pull us back. So what I'm going to do is I want to show you a flow chart of what an eviction looks like. So the flow chart I'm going to show you is the flow chart that I'm giving away to all my clients. It's actually marketing material for SSLR, or whatever we call it. It's actually SSLR material that everybody has everywhere. And lucky to see, it gives us a very clear, easy understanding of what the eviction process looks like. So I've done this in an easy to understand way for clients to understand. So I do believe that you guys will get even more benefit out of it. But I just want to show you the process. So basically what we've done up to this point, this the first seven steps of the process, this is what we did yesterday. So lease agreement, bridge, cancellation, and then we're going into the eviction. So let's quickly recap. Somebody is asking to take control. I'm a bit of a control freak. Karen, I'm sorry, unless you really want me to. I wonder if you accidentally hit that button. Was it an accident? I mean, I'm going to ignore it then, but it's not because I don't want to give you control. Alrighty. So this is what we did yesterday. Remember, we spoke about a lease agreement and what happens if a tenant doesn't pay rent or doesn't comply with the terms of the agreement. You need to do a letter of demand. Please ignore my term letter of demand. We know it's a terms letter or a MURA letter, but like I said, this is what I give to my clients as well. If the CPA applies, you're going to give 20 business days. If the CPA doesn't apply, 7 days. If the tenant remains in breach in both occasions, we cancel the agreement. Now we move into our notice of motion. So to give you a bit of a easy way of understanding a residential eviction, to go through the day, and then we're going to break it up in smaller parts to really understand what we are talking about. An eviction is very simple. An eviction, and remember guys, I'm only talking about residential evictions. So evictions in terms of pie, we're going to do the whole pie Esther thing later. I just want your brains to start processing this particular flowchart before I get into more details of it. And so an eviction is a thing that comprises of 3 parts. So the first thing that we have in an eviction, guys, somebody's mic is not on mute. Please check if your mic's on mute. If you, okay, somebody's mic's still not on mute. I'm going to keep on nagging about it until it's muted. This is what you have to do. look at your screen. If you don't have a line through your mic, it means you are the one that I'm moaning about. Okay, so you have a main application. In this application, you are asking for eviction. So your prayers are as simple as eviction, potentially an interdict, and I will tell you about the interdicts later, interdicting the person that's been evicted from re-entering the premises. And then you're also going to ask for a cost order and obviously alternative relief just for funsies. So this is your application, your main application, in which you're asking for eviction. Then you have a second document. Your second document is your ex parte application. Your ex parte application, you're simply approaching the court and you are asking the court to provide you with the authorization of the form of your notice in terms of section 4.2. I promise we're going to go into a lot of details on every one of these documents, so don't stress about it now. I'm just giving you an overview. Ex parte application, asking for authorization of your form for your notice in terms of section 4.2 of PI, and for a service director of that notice. And then you have a third document, which is your notice in terms of section 4.2 of PI, which we will go into a lot of details. Those are the three documents you have in every single residential eviction. You can't do it with anything other than that. Luckily, our magistrate courts now got the memo as well, and I do believe that all our magistrate courts and our high courts are now running the same process. If you are still in an area where the magistrate courts does the ex parte application in chambers and allow you to serve all three documents, your main application, your ex parte application, and your 4.2 notice at once, just smile politely and don't try and correct them, because that is the quickest way you can do it. In Gauteng, I must say, I haven't seen a match court that does that in a while. Same in Cape Town match, but then again, I do believe there will still be a magistrate court here or there that I haven't been to, or that we don't practice in, like Pofadder or Kuruman, which are still following the process where all the documents are served at once. For those guys, I'm going to leave that, just a quick mention of that at the end when I'm done with all the documentation, but I am going to explain the process that should be followed. This is the process in terms of Cape Killarney. The process in terms of Cape Killarney is the correct process. This is the process that's followed in all our high courts and in the majority of our magistrate courts, and this is the process that you are seeing here on the on my flowchart. All right, I don't want to move that one quickly. Good. So what you have is you have your notice of motion and your founding affidavit. This is your main application. This is your eviction application. This is the document where you will have your case number attached to it. Well, remember in the old days when matters were issued by court every day. So how it happens in your court currently, whether you're using case lines in the high courts, if you are using a magistrate court system, this could be different from from court to court currently, but the principles are exactly the same. Practicality might change a little bit, but not too far. It won't be too far off. Once we then issue that document, that must be served by sheriff. So I will give you a few practical tips around service as well, except for the one that I gave about bringing in an application if you struggle with your sheriff. But that document is then served by sheriff. Normal court rules apply. Regardless, match court, high court, normal rules apply. Once you know that this matter will be unopposed, so your time period to file the notice of intention to oppose has lapsed, you can bring your ex parte application. However, if the matter becomes opposed, so you receive a notice of intention to oppose, your process is going to follow a slightly different process but this we know because, I mean, we do appreciate that as soon as something becomes opposed, the process will look a little bit different. But let me take you through the unopposed process, and then I'll return to opposed. If the matter is unopposed, the moment you are on day 5 after service of your notice of motion and your founding affidavit, you can bring your ex parte application. So depending on the court that you are in, if you are in the High Court, your ex parte application must be enrolled like a normal interlocutory application. Currently, you're going to do that over case lines as normal, and your ex parte application will be heard over Zoom or Teams, whichever system your court uses, in the normal motion roll, on the normal motion roll. You bring your ex parte application. Your ex parte application, the court will then authorize the form of your notice in terms of section 4.2 of PI, and the court will also give you a service directive. Currently, guys, on the service directive, there are a lot of things that we can do, and I will go into a lot of detail on that when we get there. But this gives us a very good opportunity to tell the court what is happening in this matter, to get a unique service directive if you need it, currently in normal life, I mean pre-COVID life, and currently and going forward as well. Ex parte application, very important. If you don't ask for a specific service directive, the service directive that the court will give you will be that you have to serve the 4.2 notice on anybody older than 16 at the premises. So if that's not going to work for you, you're going to tell the court about that in your ex parte application. Your 4.2 notice is then served in terms of your service directive, and the only requirement here in terms of the Prevention of Illegal Evictions Act is from the day of service of this notice in terms of section 4.2 until the hearing, you need to have 14 calendar days passed before you can get there. Anyway, makes sense because that's anyway the 10 court day time period before for notice that you need to give before you can be in court. So it coincides and it makes a lot of sense. I think right now the 14 calendar day thing is not even almost a problem. If you are lucky, you're going to get a date towards the end of July, August anyway. So you have more than 14 days. Just make sure you have that clear, especially if you get into a position post-COVID where our courts are going to be automated and running much quicker and more effectively. Make sure that you don't accidentally enroll a matter without the 14 days, calendar days from service of your notice in terms of section 4.2 and your hearing. The matter becomes opposed. You're simply going to file your answering affidavit, replying affidavit, and you're going to fall back after service of the replying affidavit. You're only going to do your ex parte application then. So you follow your entire opposed process until close of pleadings, and then you bring your ex parte application. So very important, don't try and sneak your ex parte application in here while you're exchanging pleadings. Finalize exchange of pleadings and until the point you reach litis contestatio or the replying affidavit was filed, then you can bring your ex parte application. Usually by this time you have an opponent, you have an address, and you are allowed to ask the court that the service directive then indicates service on the attorney of record. However, the courts are usually reluctant to do that. The court still requires service by the sheriff on the respondents. Personally is always ideal. This is what the court actually wants. And then you get, in both cases, to your hearing. The matter is heard on an opposed or unopposed basis, and your court order will be granted there. If everything was done correctly and the court is satisfied that the eviction order may be granted, the court will decide what would be just an equitable on the date when the person has to vacate, and how long after that date can the sheriff be authorized to then execute the eviction order. Something very important here, guys, is if the court at any stage through this, look at the process and realize that your respondent has some or the other personal circumstances that will make it more difficult for them to vacate, but you haven't brought it into your papers. It's a very unfortunate position to be in. So put everything on the table to enable the court to comply with the provisions of Section 26 of the Constitution. The court can only grant this order once they are satisfied that they have really considered the personal circumstances of this particular respondent. It's a very important thing to consider. All right, so that was a flowchart. Why I like doing that before I start is I'm a big picture person, so I want to see where we are heading, and then I'll break it up into little pieces. So I hope that made sense so far as an overview, and now we can go into a bit more detail. So let's start. Now I'm going to give you a slideshow again. How surprised are we? Good. I did something stupid, and now it looks like I'm picking my nose as well. I promise I didn't. The screen froze while I was rubbing my face, which we shouldn't. We shouldn't be touching our faces. Alrighty. Let me just share this screen with you. Cool. Sorry guys, I'm just struggling quickly. Hello, Yella. The joys of slow computers when you are trying to do something. Just a second. There we go. There's it. That's much better. Good. Okay, there we go. So something very important, just quickly, the Constitution. I can't talk about evictions without touching on the Constitution. So obviously, our Constitution forms the basis of our legal system, something very important. We really can't act outside of the Constitution. And we know that Section 25 of the Constitution protects the right of ownership as a full, secured, real right. I actually thought about this last night, and I found it actually quite funny that a year ago, at this stage, a year ago, the entire South Africa was in absolute chaos and craziness about potential amendment of Section 25. And it's interesting that the moment there's something bigger and something more pressing like COVID, I haven't heard anybody say anything about amendment of Section 25 of the Constitution in a good, 3-4 months' time. So that's a pleasant little surprise and a pleasant little pause from constitutional drama for us for a little bit. So let's be grateful for what we have. Section 26 of the Constitution, however, is relevant. I was on about it yesterday as well. Section 26, obviously giving somebody the constitutional right not to be evicted unless there is a court order evicting him. And I find this actually quite interesting in the lockdown regulations, where people are very surprised with the regulations saying that nobody may be evicted, except when there's a court order. And I'm thinking, Yella, this is nothing new. This has been the way like that since promulgation of the Constitution. So I'm actually quite surprised that people are this surprised. It makes me realize that there has been a lot more illegal evictions that's been happening in South Africa than we as practitioners realized, simply because I think in our heads, if we talk about an eviction, we talk about legal evictions and a court order, where I think for many other people, an eviction does not necessarily mean a court order. And I think there's some education required from our side as legal practitioners as well, just to explain to the country how these things are actually supposed to work. All right, the Prevention of Illegal Evictions Act, guys, I really hope you have all read him. I'm quite sure I've sent you a copy of the act as well, but you all have LexisNexis and Juta, so I'm quite sure you've seen it. Please give it a read over again. PI is a very short, very simple piece of legislation, really not rocket science. If you go into Section 4 specifically, all the process on how it should work is already there. Obviously, we had Cape Killarney giving us a bit more clarity on how it should work. And then after that, we've had beautiful cases since then, like Blue Moonlight Properties, Modded Clip, and lately things like Berea and cases like that, where we have a lot of clarity around what the courts are expecting from us when we are doing an eviction. But what's the story with PI? Why do we have this? So as I explained to you yesterday, the weight of the right of ownership compared to the right of occupation is so far apart from each other. It's such a burdensome right. If you are the one with the right of occupation and you're trying to compete with this right of ownership, it's such a strong right that an occupant could very well be overpowered by the right of occupation, and that is obviously not something we want to do, because we do not want any tenant or any occupant ever to be at the mercy of the landlord. We want these relationships to work well. So the purpose of PI was to bring in regulations around eviction. Remember, the name of the act, I didn't write the full name because that will take up a full slide, is the Prevention of Illegal Evictions from and Unlawful Occupation of Land Act. I always want to paginate, I always want to punctuate the name of that act. I feel a comma could really help us a little bit there, or even a semicolon. I can work a semicolon into that act's name. But the Prevention of Illegal Evictions Act deals with the prevention of illegal evictions, and it deals with how evictions should be done legally. What is it actually? How should we do it? How should this work? And it's something very important to know about and to be able to utilize. And even more importantly, it's very important for us as legal practitioners to explain to our clients that there is no such thing as, they call it, squatter rights. I've been in the property industry way too long, so I know the agent slang and the landlord slang around these things. They still believe there's this thing called squatter rights. We know there's no such thing in our law. We have the Prevention of Illegal Evictions Act, which is a piece of legislation about evictions. It is the thing that tells us how to do evictions. There's nothing in our law that says a person is allowed to occupy somebody else's property free of charge for as long as their heart's desire. It's not an option. It's not part of the things that could happen to somebody. The thing about PI that does cause a bit of confusion sometimes is in terms of PI, if somebody has been in illegal occupation, guys, not in occupation, illegal occupation, for a period of more than 6 months, the landlord could be held responsible to provide that person with alternative accommodation. Now, what that looks like in practice is the court will never grant an order to say, shame, Mr. Landlord, you haven't taken action for a period of 6 months, and now you're in front of me with an illegal occupant after a year. Don't you please just want to book him into the Four Seasons for us for 3 years? That's not an option. That's not going to happen. How the courts apply this rule is the courts simply allow the illegal occupant a longer time period to vacate the premises than what they normally would. Normal situations on residential evictions, the court allows the person a month or 2 to vacate before we can send the sheriff to execute the eviction order. In commercial properties, it's usually an immediate eviction. And the court might say, listen, shame, this person has been in illegal occupation for 2 years now. It's only fair to give them 6 months to vacate or something similar like that. So alternative accommodation will never be alternative accommodation in the sense of you need to give somebody occupation. There is no obligation ever on a private citizen to provide another citizen with accommodation free of charge. It's very important to know this, and it's very important to tell your clients about this because they are usually scared about this. There is a lot of case law that is very clear on that. The purpose of PI is simply to ensure that the court has the necessary information in front of them to enable them to provide an order with a date that is just and equitable to evict this person. The effect of PI is obviously that every single eviction that has to be done of illegal occupants has to be done by court order following this particular process. But we can do evictions that is not in terms of PI. Our commercial, retail, industrial evictions are not legislated. And so we simply do those evictions in the form of a normal reivindicatio. So you're going to plead what you normally plead in a reivindicatio. This person had a right to be in the premises, that right was cancelled, and that person is now evicted, should now be evicted, to get the right and the use of the thing back, which is now a property. And then we also have a few other options. We have the Extension of Security of Tenure Act, ESTA. So in your study material, you will see that I have done a column with comparisons between ESTA and PI. You can have a look at that. I just want to check what the page number is. Luckily, 16. Luckily, I have a very handy candidate attorney next to me. Thank you, Kelsey. So page number 16 on your study notes, you will see I've done a comparison between PI and ESTA. If you don't have it in front of you, don't stress. You're not really going to need it right now. I'll give you the short explanation. So very often I find that practitioners believe that PI and ESTA are sort of the two options in terms of which you can do a residential eviction. The problem is, the moment you have that kind of thinking, you're going to accidentally jump to a potential way of thinking that PI and ESTA are, for all intents and purposes, pretty similar, but it's really not. It's not even almost. PI deals with how an eviction should be done. ESTA, however, creates rights. ESTA creates a right of occupation for a longer period than you would be able to have somebody find alternative accommodation in terms of PI. So what ESTA does is, in certain circumstances, for instance, if somebody has been in occupation of the premises with consent for a period of longer than 10 years, and they are now over the age of 65, you won't be able to evict that person. So as much as PI creates the recipe and the route that you need to follow to obtain an eviction order, ESTA sits on the other side. ESTA limits our ability to do eviction orders and is much more burdensome than PI. The reason for this is the difference between the relationship between the owner and the occupant. In terms of PI, the relationship between the owner and the occupant is typically a contractual relationship, be it a verbal, written, tacit agreement. It's of a contractual nature, where ESTA deals with consent. Consent rarely has a contractual basis. So the big difference here is, under PI, somebody had a right to occupy. That right has been cancelled. That person is now an illegal occupant and has to be evicted. Under ESTA, the person in occupation had consent to reside on the land. The owner of the land now wants to withdraw the consent, and that person now has to evict it. And some of those people aren't allowed to be evicted because of the consent from the owner. And the owner will either have to find an alternative place on the land for them to reside, or they get a right where they're going to be able to stay on that property pretty much for as long as not just they live, their children as well, because this consent in terms of Esther carries through generations. So if somebody had consent 50 years ago, their kids then resided in that property under the same consent. That person, the original holder of the consent, has passed away. The people currently in occupation of the premises are deemed to have exactly the same consent as the person that they've resided through and under. Very different pieces of legislation. So I'm not going to talk too much about Esther, but I think you guys need to know the difference, because you very often commence proceedings, and a while later you realize, oh my goodness, I'm on the wrong piece of legislation. That's obviously fatally defective. So the big thing about Esther is there's this misconception in law that you use Esther whenever you do an eviction on a farm. So that's completely wrong. That's not the case. Esther does, however, relate to land that is rural or peri-urban land, whereas PI relates to land in the Republic. So anything, PI can also apply on rural and peri-urban land. Esther, however, can never apply to urban land. I hope that makes sense. So your first question is, where is my land? Do I have a rural or peri-urban land that is not encircled by township? Very important, guys. This has nothing to do with zoning. So your zoning of the premises will not give you any indication on whether this is PI and Esther. I'll tell you a little fun story. So my office is in Constantia Office Park in Roodepoort, and right on the corner. So for the Gautengers, we're right across the MTN building on the N1. So right outside, so we're really next to the N1 in Johannesburg, and we have a garage, a Sasol garage by the entrance of our office park, but there's a little corner going onto 14th Avenue, and that little corner is still zoned as agricultural land. So I don't know about you, but if somebody rocks up there and they're going to occupy there, even if they had consent, that can't possibly be an Esther eviction. That is a PI eviction, even though the zoning of that little corner is agricultural. I mean, I can theoretically have a cow run around there if I have consent from the landlord, and that would be allowed. That's the difference between zoning and the type of land that you have. Zoning doesn't give you any indication of the kind of land that you have. Zoning has to do with what we can use the land for. So Esther doesn't talk about zoning. Esther talks about location. So if the location of the land is rural or peri-urban and it's not encircled by township, you have to dig a little deeper because it could be an Esther eviction. The second question is the occupant. Did the occupant occupy on consent, or was there some of the other contractual basis for the relationship between the landlord and the tenant? The fact that you use the terms landlord and tenant immediately points to a contractual relationship. It's probably going to be PI. Consent would typically be a farm worker. So a farm worker that has been residing on the land, he had consent to do that, wasn't tied in with his occupation per se. I mean, he's by occupation now, I mean job. He didn't have the right to occupy the premises because he worked on the farm, and that was done in writing. It was simply the farmer said, you are welcome to stay here, you and your family, and that is the kind of consent we are talking about. And then there's a last little thing about the occupant. If the occupant earns a salary that is currently 12,000 Rand or more, it can't be Esther, it will be PI. So those are the major differences on PI and Esther. Don't accidentally fall into the ESTA trap where you can do a PI eviction. So ask yourself these questions when determining whether it's PI or ESTA. If it is PI, you're going to carry through the you're going to carry on with the process that we are discussing today. If it is ESTA, you can't go to the High Court unless the parties consent. High Court doesn't have jurisdiction for ESTA without consent from the parties. You will have to go to the Land Claims Court or the Magistrate Court. And the big thing here is the best advice I can give on an ESTA eviction is don't try to hop out all guns blazing with an eviction order as you would with PI. This is negotiation, 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 negotiation. You need to talk to the people, find out what they want, if they can relocate, how they can, the landlord can, the owner can facilitate relocation. Things like that is usually much easier than trying to follow the legal process to get an ESTA eviction done, simply because ESTA very often will rather give a right than take a right away. So I'm not an ESTA expert for very good reason. It's I don't think it's something that should go through courts very often. I think it's more a negotiation thing. But I've done a few ESTA evictions. It's a slow, painful 2-year at least process to get an eviction, ESTA eviction finalized, provided that the court does it in the true spirit of that particular piece of legislation. All right, so that was ESTA. It's been real. We're going to put her in a box and carry on exclusively on PI. So let's talk about locus standi under PI. So please forget now that I said anything about ESTA, and now we are just focusing on residential evictions in terms of PI. Before I get into locus standi, let me just quickly clarify something again on PI. PI applies to any eviction where the occupant, so the illegal occupant, is occupying the land and is using that land as temporary or permanent shelter. So I very often get clients calling me and saying, it doesn't have to be an eviction. This is not an eviction. This is actually, it's just trespassing. And I say, okay, how long has this person been there? And they say, no, they don't really know. They just got there and they found them there. True South African proverb, I found them there. So I got there and there was people, and you think, my goodness, this is a very interesting situation. It's not trespassing, guys. Trespassing is when somebody enters into a premises without consent. But what PI is saying is, if somebody is using a premises for temporary or permanent shelter, if somebody broke into a place and he is now using that as shelter, that is a PI eviction. So how do we know if somebody is using it as shelter? I must say, if there's a blanket and some stuff, that is how you know somebody is using it as shelter, and you need to do a PI eviction. Is that unfair? Yes, but so is life. Life is unfair. And the truth is, you can't, the purpose of PI is to ensure that people are not left homeless or destitute. So somebody that has to break into a place for shelter, that is the ultimate person that needs alternative accommodation, because that person is already homeless and destitute, and once this eviction is granted, will definitely be homeless and destitute, and that person has to be provided with accommodation, not by the owner of the property, but by the municipality in the area. Blue Moonlight Properties is very clear that the obligation of providing alternative accommodation does not sit with the owner, does not sit with national government, but what sits with local government in the form of the municipalities. So very important to know this. Don't accidentally run into an eviction unless you are sure that you are using the right legislation and the right process. Even more importantly, the property type will not determine whether you need to use PI or not. The occupant does. If the occupant is an illegal occupier that is using the property for temporary or permanent shelter, that is a PI eviction. I've seen this so many times. commercial evictions. So you get an instruction to do a commercial eviction. You're very excited because that's a quick, easy eviction, way to impress your clients. So simple, easy evictions. And you commence the process. Eventually, you send the sheriff to execute the eviction. And the sheriff says, listen, I'm sorry, I'm not going to execute your order. There are people living on this premises. And you say, what? You need to find out when you do a commercial eviction if there are anybody residing at the premises. Very often, industrial properties very often have people residing on the property. Ask your client to attend to the property and confirm with you in writing that there is nobody using that property as accommodation. If you don't do this, if you don't check with your client exactly what the circumstances is around the property, and you commence with a commercial eviction where there is actually somebody in occupation of that premises, honestly, your client is going to be a very sad panda, and for very good reason, because the truth is you have now wasted the entire eviction order simply because you won't be able to execute that order because you haven't obtained the order in terms of the correct piece of legislation. So I see it in terms of industrial property very often, but actually also even retail and commercial. I have seen, especially in your inner city buildings with more multi-purpose buildings, so your residential on top and your retail at the bottom type properties, where you have a shop selling all sorts of fun things. A good indication would be the items that they are selling. If they are selling cell phone covers and random stuff that you can hang in your car, there is a very good chance that somebody is living in that shop. And so ask the owner to attend to it. It's usually like a piece of material of sorts, separating the cash register part of the shop. And then there's stuff happening at the back. The stuff happening at the back is not necessarily a storeroom. Don't assume storeroom. Confirm that there isn't an entire family living in that shop. I have clearly done too many evictions where I was surprised with a family behind a curtain in a little shop. So if that is the case, regardless of the property type, regardless of the lease agreement, say for instance, the lease agreement on a commercial property says that the tenant may only use this premises for the purposes of running this business. Okay, so the tenant is in contravention of the lease agreement by occupying the premises. Brilliant. We have remedies to deal with that. PI says if somebody is using the place as shelter, PI. So remember, the fact that somebody is in breach of a contractual obligation doesn't absolve the other party from complying with legislation. That's, I think, a very important point that I have to make. All right, so now that you know you have a PI eviction, so you are evicting whoever, family that's been staying in a property that they've been renting, they haven't paid their rent, and you cancelled the agreement. If you are evicting a huge piece of informal settlement that just popped up, and there are 150 shacks of people that just popped up somewhere, you're going to use PI. If you have a hijacked building in the inner city and there are just random people living there, you're going to use PI. If your client calls you and says, I had this property that's been standing vacant for 2 years, I didn't have the money to do the flip that I wanted to do, and now there are random people living there, you're going to use PI. You're going to use PI every single time unless you're going to use ESTA, or unless there are no people occupying, then you're going to use a revenue. Okay, so if there are people, you're going to use PI. Unless you're going to, unless you have to use ESTA. I hope that makes sense. So every time that happens, you're going to commence a PI eviction. Very important. Locus standi is your starting point. So locus standi, first thing is your owner of land will always have locus standi. An eviction is very, very simple. I've shown you the process. We have 3 documents. and we have two things to prove. The first thing we need to prove is ownership. So you need to be able to show that the person bringing the eviction application or asking for the eviction order has the right of ownership. Why the right of ownership? If they are not the owner, they do not have a strong enough right. Right of occupation is a personal right, but it's a relatively strong personal right. So somebody with another personal right to the property will not have a strong enough right to have a right that's stronger as the right of occupation to have that person evicted. So you have to be the owner of the property. You need to prove ownership of the property before you will be able to obtain an eviction order. The second thing that you need to prove is illegal occupation. So when you can prove ownership and you can prove illegal occupation, there is no two ways about it. You will get that eviction order. I will talk to you later about a few exceptions to that rule as law goes, but it's very important to know. Ownership, illegal occupation, that's the only two things that you need to prove. We prove ownership simply by attaching a deed search report, whether you use Lightstone, Windeed, whatever your heart desires. A deed search report is sufficient proof of ownership. Please don't try and get your client to give you a title deed. I think I've done more evictions than I can count in my life, and I have never, ever in my life had the need to provide a title deed to prove ownership. Your deed search reports are more than sufficient to prove that. I've said this yesterday already when I said please do a deed search when you take the instruction to ensure that you have the correct property details and the correct ownership detail, the correct owner details. But because while I already said that yesterday, by the time you start drafting your eviction application, ideally I would like you to already have your deed search in your file. But if you don't, like, seriously, do it quickly now before you start drafting, to ensure that you have the correct owner details and that you can prove ownership. So locus standi, the owner of the property, has locus standi or his executor or his curator bonus. The curator ad litem as well, but why I'm referring specifically to a curator bonus in this circumstances is your executor or your curator bonus. Remember, that is not somebody that's acting on behalf of the owner. That is somebody that is acting instead of that person. So if somebody has passed away and who's moved on, he can't litigate, and his executor will be the person bringing that eviction application on his behalf. I think this is a very good moment to point out, guys, please remember, a lease agreement is not affected by death. Lease agreement of the landlord or the tenant, lease agreement still continues, and the estate of that particular deceased still carries all the rights and obligations in terms of a lease agreement. Death does not affect a lease agreement in any way. So please keep this in mind. So if the owner of a property passes away and the tenant then stops paying because he for some reason believes he doesn't have to pay rent to a deceased person, the executor of that estate will follow the normal processes in terms of the lease agreement. So don't try to then say, but the person passed away, so the lease agreement cancelled. The death doesn't affect that. Curator bonus is obviously appointed in a situation where somebody is not of sound mind, or yeah, that is the correct way of saying it. I'm always so impressed with myself if I get something out diplomatically. A curator bonus or then a curator ad litem, but in this particular cases, I just want to talk about the executor and curator bonus. They are going to step into the place of the owner, and you're obviously not going to cite the owner as well. Why I'm saying this is the other person that might have locus standi is the person in charge of land. And the Act defines the person in charge of land as a person who has or at the relevant time had legal authority to give permission to a person to enter or reside upon the land in question. This is not the rental agent, guys. This is really not the rental agent. This is somebody that has power of attorney. This is somebody that has specific power of attorney, giving him the right to have people sign lease agreements, to accept the rental payments. This is not a rental agent. This is not somebody's wife who suddenly want to take control of the property and she doesn't have a power of attorney. This is not the child of older parents that said, oh, please, don't you want to do us a favor and run this rental for us? This is somebody with the power of attorney. It's very important. It's a full agent that is acting on behalf of the owner. In these cases where you are basing your locus standi on this particular situation, on a person in charge of land, please, please, please make sure that you attach the necessary authority to prove that the owner allowed this person to take charge of the land and to act on their behalf. Ideally, I would like to see a power of attorney here, or at least a written agreement between the parties, allowing the person, giving the person the rights to allow people to enter the premises and reside on the land. In these cases, I would like to see the owner at least as a second applicant. You don't need to do a confirmatory affidavit or anything for him, but I would like to see him as a secondary applicant, just so the court is comfortable with ownership. Like I said, person acting as an agent, this is a power of attorney. Then, like I said, please have them cited so the court doesn't worry about that. Also, funny enough, Section 6 of PI gives an organ of state or the local municipality the authority locus standi, to bring an eviction application. That's why I know City of Cape Town enjoys an eviction, COJ as well, City of Joburg as well, but it doesn't happen that often, but there are municipalities that has to attend to evictions on land that does not belong to them, and they do have the right to do this. This was also confirmed in this case, Mangaung local municipality and Mashale, very important case where the court just confirmed that the municipality does have locus standi to bring an eviction application, even on land that does not belong to the local municipality. Alrighty, so that's locus standi. I think it's a very important thing. If you don't have the right parties bringing the application, you obviously sit with a fatally defective application. Very important. We're on application. So the person signing the founding affidavit, please make sure that the person signing the affidavit that you prove and you plead, well, you plead and you prove the right to do this. So say, for instance, you have an executor of an estate. The executor can't attest necessarily to the facts of the relationship between the landlord and the tenant and how it broke down. How, for instance, the tenant didn't pay rent for months. A rental agent might be able to do that. So my recommendation is always make sure that as you draft your pleadings, you can prove that the person attesting to your founding affidavit is the best possible person to do that. If in my situation that I just explained, if the executor doesn't have personal knowledge to attest to this affidavit, he can still be the person attesting to the affidavit, but bring your rental agent in to the proceedings just with a confirmatory affidavit. They don't have to be a party or anything. Just have the rental agent do a confirmatory affidavit to attest to the rent that hasn't been paid, the letters of demand that's been sent, the method in which it was sent, things like that. You can go a very long way with a confirmatory affidavit, so make sure you have the right parties pleading to your proceedings and attesting to the evidence that you are giving. Alrighty, then this is my favorite slide. I think I've been using this exact slide now for a good 9 years, except when I rebranded and changed SSLR's logo into this little house about 4 years ago. I must say it gave a whole new little spin. Look at my women-headed household in the door. Isn't it cute? Oh, my mother. So equity provisions. And the 4 equity groups that we have in terms of PI are elderly people, children, disabled persons, and women-headed households. What's the story with this? If you have someone of one of these people in the property, are you not able to evict them? No, definitely not. I've done evictions of all of these groups of people. What PI envisions with this is PI wants to know about this. PI wants to know whether you have one of these parties in the premises, to enable the court to comply with the provisions of Section 26 of the Constitution, demanding that the court has to have knowledge of the people's personal circumstances before they grant the eviction order. So if you have one of these parties in the premises, plead it in full. Please, 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 guys. Our job as practitioners is to take the court into our confidence and give the court the necessary information to make the correct judgments. If you know that you have a disabled person in a building, it's very important for you to bring that to the court's attention. Tell them what kind of disability they have, because disabilities aren't all created equal. Some people's disabilities are relevant to know about, but it doesn't affect them. For instance, I'll tell a good story. I've once had somebody that I had to evict that was in a wheelchair. Now, the problem with a wheelchair is it's really, our society does not cater for wheelchairs, which we should really talk about and change. But to relocate somebody in a wheelchair was an absolute nightmare. The court ended up giving them 3 months to vacate, and to be honest, I gave them a further month after that before I didn't have to send the sheriff, luckily. But the problem with a wheelchair is it's not easy to find alternative accommodation for somebody like that is wheelchair accessible. Somebody that is deaf, for instance, it's a disability, it's a real disability. It's not really going to affect how easy you're going to find alternative accommodation. Somebody that's blind, blindness, unfortunately, gives a similar problem as a wheelchair, because it takes somebody a longer time to get used to a place to be able to reside in. Take this into consideration when you plead. Bring this in your founding affidavit. Do not put yourself in a position where you have to, after the fact, in a replying affidavit, say, oopsie, I actually knew about it. If you don't, this is why PI exists. So if you don't have this information, tell the court that you don't have this information. Tell the court that this is the person that your client saw once. They haven't contracted with these people. These people are random squatters. They have no idea about the personal circumstances. And that's cool, because that's why PI exists. That's why we allow the occupants to come to court and explain what their personal circumstances are. So it's very important to keep that in mind and to make sure you bring it to the court's attention. Children, elderly people, plead that, make it clear. Women-headed households, a very important point. Remember, PI is all the way from 1998, and same-sex marriages was legalized in 2002. So please keep in mind that the two pieces of legislation didn't really talk to each other here. Women-headed household in terms of PI, so in 1998, the intention was single mums with kids that has to now find alternative accommodation that is safe. They have to move without the support of a husband. I'm sorry, you can't see me, so you can't see me frowning. I actually always believe that women-headed households and those single mums are potentially the strongest players in our societies. But anyway, be it as it may, extra little benefit there. But it is a sexist provision. I agree with that. But I suppose it is what it is. So let's not delve into that. But if it's a same-sex marriage, they don't have the same privilege as the single mother, and you need to plead it accordingly. So plead that it is a same-sex marriage, and that they are in fact both female, and it means that there is a female-headed household, women-headed household, but they do not deserve the protection from PI in terms of the equity provisions because they are two adults and they don't have the same privileges. So as the Act envisions, because the intention of the women-headed household, like I said, is very different. So just plead that in. It is something very important, and it actually happens often that you might have to plead that, so please just keep that in mind. All right, so that's the equity provisions. The process, I was hoping that I can have enough time to talk about process, because like I said in the beginning, process currently is very different from court to court. Not because, I mean, evictions has already been very different from court to court. But currently, with COVID, honestly, guys, I'm not even going to try and tell you which process your court will follow, simply because in all the courts that we are practicing in, it's different from every court. And the truth is, what we are currently doing as SSLR is we will send a candidate attorney or a messenger or somebody to the court with the documentation and ask them how they are currently doing their evictions. Because more ex parte applications, even in magistrate courts, are done over Zoom or over Teams or whatever the case might be, and some are still doing it in chambers. Most of the high courts are running their things, all their matters through case lines, which is brilliant. If only it wasn't so slow, but it is what it is. And you know what the process is, so make sure that when you send a messenger or somebody to court with your documentation, take all three sets. So take all three parts of the application: your notice of motion, your founding affidavit, your ex parte application, and your forgery notice. Take all of that with you. Find out how the court is currently doing it. If you are struggling with a court that doesn't want to issue an eviction application, please, 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 please take the necessary action. Go to your attorneys association, go to the law society, well, the LPC, whoever is necessary there to help you to get your court to function. Our courts will close, our deeds offices will close. It's going to happen every now and again. If somebody got infected in the court will be closed for a few days. You will struggle to issue our applications, but guys, persistence is key currently. Our tenacity is what's going to change the law now. And I think it's our obligation as legal practitioners to push forward and to make sure that we don't sit back and say, because things are uncomfortable and we don't know the process, we're not going to do it. We need to figure it out as we go along. And I am very sure, I never thought there would be a moment in my life where I present a webinar to legal practitioners and I say, guys, I have no idea how your courts are going to do this, but this is where we are. And I would rather say, I have no idea how each and every court in the country is currently functioning, but I don't think any one of us does. And the truth is, the only option that you have is to talk to the clerks of the court. If you have a good relationship with one of the magistrates, maybe give them a call, find out how they are doing it. Personally, go to the court and figure it out. And don't just take their answer as the answer. Take the regulations with you and guide them through this a little bit as well. And the process will be different in every court currently, but the full bigger picture process will be exactly the same. But the nitty-gritty things of when and how you do your ex parte applications will differ from court to court. And my suggestion is get onto the groups like the attorneys associations. We now currently have a West Rand Attorneys Association WhatsApp group. And to be quite honest, as much as it drives me to complete and utter drink because there's like my phone is going mad, it's actually quite convenient. So talk to your colleagues. I spoke about the Property Law Alliance last night. I have a very good relationship with other eviction expert attorneys. We have these conversations constantly. Where are you struggling with the sheriffs? Why are you struggling? What can we do? Build these relationships, and I really want to invite you guys to join us on the property the Property Law Alliance Facebook page. If you have questions, if you have issues, talk to us. All of us are very keen to work together. Like I said, the Property Law Alliance are 3 different firms. In truth we are all eviction specialist firms. So we are direct competition, but now is the time for us as legal practitioners to stand together and work together to get us through this, so we can understand how and what we should be doing. So unfortunately, that's my answer on process currently. I do not know, but find out and let's push forward. Action or application, I'm not going to talk about it too much. I'm just going to echo what I said yesterday about this topic. Please make sure that you follow application process as far as you can, simply because it's the quickest, most effective method and process to follow. However, when you have a factual dispute that will have to be resolved by oral evidence, you don't have a choice. You have to be on action. However, guys, honestly, I think I've had about 2 cases in my life. Well, not in my life, in my time specializing in evictions, where I had to go on action procedure because there was weird verbal agreements. Most verbal lease agreements, no need for action procedure. Clarify the terms in writing while you place the tenant on terms. Agree to not agree. Just set out your terms in correspondence already, and you will already be able to show the court what the terms were, because if the tenant specifically disagrees with what you were saying around the breach that they are in and the way you drafted the Mora letter, you will be able to resolve your factual disputes on a verbal lease agreement in correspondence already. So don't just jump into action because it's a verbal agreement. See how far you can take the matter and resolve your disputes prior to commencement of your proceedings, and you can be on application as well. My best trick here is most of our fights and our actual big disputes when it comes to evictions has nothing to do with the eviction. It has to do with the money part of things. So the tenant will say, I only owe you 20,000 Rand, and the landlord says, no, you owe me 22,000 Rand. Okay, whether it's 20 or 22, the tenant is in breach, and we all agree that the tenant is in breach. Even the tenant knows he's in breach. It's the amount that's bothering him here. So my suggestion is always take your rental claim as far away from your eviction as you possibly can. If you try and mix your eviction and your rental claim up in one go, bad things are going to happen. You can do that smoothly with a commercial eviction. And like I said, when I do the commercial webinar, I'll go into that kind of detail, how you do that in commercial and residential, and don't try and mix it up. The reason for that is you're simply going to open an unnecessary dispute. So pull your money fight away from your eviction. Get it in a separate action. Issue summons for that. Use your rent interdict summons. Issue your summons. And get going on that under a separate case number. Then proceed with your eviction on application. That will be the quickest, easiest way of getting it done. Please don't try and mix it up. Very often I advise my clients to let me do the eviction and they go to the rental housing tribunal for their rental claim, because the rental claim is an absolute nightmare. Very often you don't get your money back. You get a court order and then client is upset with you as the attorney because it ended up costing him 7,000 Rand for an empty judgment that he can't execute on. So maybe consider sending your clients to the tribunal for rental claims and you proceed with the eviction on application, or you just do your rental claim separately on action and eviction on application. Quickly before we break, the ex parte application. Reason for this, I told you, was to authorize the notice in terms of section 4.2 of BI and to get a service director for that. So very important, when you authorize your form in terms of section 4.2, please make sure you attach this form to your ex parte application. Otherwise, how would the court know what they are authorizing? With that said, you can attach an affidavit. You don't have to, but you can attach an affidavit on your ex parte application, giving the court some indication of the reasons why you are looking for an alternative service directive. So say, for instance, the sheriff struggled to serve your main application. The person was never there, didn't open the door, it was chaos. Eventually you got it served. Bring that return of service into your affidavit. You can do the affidavit as the attorney of record, or you can get your client to do the affidavit and explain to court why you struggled with service and ask for an alternative service directive, for instance. Service by attaching it to the document, but also serving by email or over social media platforms or whatever. You have options. Just quickly want to say, I've done quite a lot of alternative service applications, not just service directives in terms of by commencement, alternative commencement service directives as well, through social media platforms. For instance, you can see somebody is always on Facebook or Instagram, Facebook and Instagram as a chat ability, or LinkedIn or whatever. You can approach a court and ask to serve your proceedings through those kind of methods. So especially currently, where we are struggling to trace people, where we are struggling to get hold of people, where the sheriff is struggling to get hold of people, keep that in mind. And you are always welcome, obviously, to approach a court and ask for an alternative service order or for an alternative service directive in terms of bond. So very important. You always have to do your ex parte application as soon as you know that your matter is unopposed. Alrighty, so let's take a quick 5-minute break. Like I said, I will give you a quick 5-minute break every day. I'm going to start again at 11:35 on the 2nd. So please be back. And as you come back, please don't turn your mic back on. I don't know how that happens, but please keep your mics mute. And I will see you guys in exactly 5 minutes again. I don't have to wear my mask actually anymore. Now we know I'm a good mask wearer. Alrighty, guys. I was rushing back. I saw it's 11:35, and I said I'll start on the minute 11:35, and I didn't. I'm sorry, but here we are now. All right. So the fortune notice is actually something very interesting. I'm going to just quickly move off my slides. Not because I want to see if you guys are still awake, but I can see you're awake. I'm happy to see that. Well done, Yella. I want to show you, as part of the documentation I've asked the Law Society to send to you, you will see, if I can get my hands on it quickly, you will see there is a fortune notice. If somebody can give me a bit of a nod there, did you receive that fortune notice in Word format? Does anybody know what I'm on about? Nope. Nope. So I've sent you this fortune notice in Word format, but because I want you guys to use it, I just want to make sure that you have it, but obviously we can, you will let me know just now if you have received it. But I want to take you through it because I can talk about a fortune notice for hours, but I want to show it to you. It's just going to make more sense. The purpose of your notice in terms of section 4.2 is simply to give the tenant, the illegal occupant, the ability to come to court and tell the court about his personal circumstances. I know the founding affidavit does that, but this is a procedural thing, and it just gives the illegal occupier an extra opportunity to do this. So I'm going to show it to you just now, if you have it on your screen. Okay, you guys are saying you didn't receive it. Hi, Yola. Don't worry, I'm going to send it to you. I'm that guy. Well, not guy, a person, colleague, that is going to send you the coolest fortune notice in Word format. I'm that person. I've gave you a lot of precedents, but the fortune notice is a special thing, and I would like you guys to use it. If you struggle in any way, pop me a mail. I gave you my email address, and I'll send it to you, but I'll obviously check with the Law Society to send it to you too. Oh my goodness, you do have it. I think that's the old boring one. Okay, check out this one. Let me show it to you. I just said there's a boring fortune application. This just happened. Okay, so the reason why we like this fortune application, I've drafted this with one of my associates, Claire. She is the brilliant attorney, and she does residential evictions pretty much every single day. So we work together on this one, and what makes him unique and special is we are giving the illegal occupant everything that he can possibly want to oppose this matter, and we are even doing a draft answering affidavit. I kid you not. So we're giving him all the details, all the contact details that he might need to contact, I'm in Joburg, but you guys can add yours, to find free legal representation, so the Justice Centre, legal aid, those kind of things. And we are giving them the addresses. Sometimes we go wild. We even add like telephone numbers. You need to give this person everything he possibly needs to oppose the matter. So what we are doing here is we actually, I kid you not, give them a draft answering affidavit as part of these, as part of this document. So I'll show it to you just now. As part of that, you're going to draft a document that you're going to attach that simply says, I am the illegal occupant of this premises. This is my personal circumstances. It's very important that you do that, and you need to make sure that the respondent has everything possibly that he needs to oppose this matter. Why am I saying that? It's the weirdest thing. Who has ever drafted a draft answering affidavit for a respondent? Well, me. And I want you to do it too. The reason why I want you to do it is if you use this for application, you can decide whether you want to do a guide them in the right direction answering affidavit. Simply just do the heading of the answering affidavit for them, and then just make provision for the person's name, so for the deponent, and then guide them a little bit. For instance, do a few headings like my personal circumstances. It doesn't have to be gorgeous drafting. This is somebody representing himself. So it's like that thing that you're going to be proud of if your 7-year-old does it. That's basically what we want here. It shouldn't be complex legal drafting, but you want to empower the respondent to bring his personal circumstances to court. That's the only thing we want. We want him to be able to tell the court, I am disabled, I am elderly, whatever the situation is. Reason why I want to do that is twofold. A, it's the right thing to do. B, more importantly, it will speed up your eviction. Because the court, if you need to postpone to get legal aid, if you need to postpone to find this, if you need to postpone because the person filed a half-baked answering situation, the court's going to postpone to get a proper thing filed. You see what I'm saying? The more handholding you do for the respondent, the quicker we can get the right information in front of court, and the quicker we can get our eviction orders. It's really that simple, I kid you not. So guide your respondent through the whole process of opposing the matter. Very important. Really helps. I'll make sure you get a copy of the draft that I've done, and you can then draft your own draft answering affidavit. Just give the guy a bit of pointers. Not going to be rocket science, basically the head, but it's similar to a summons. Remember, on your standard summons, you do have a little notice of intention to oppose of defend. See, this is how we know I'm an application girl. I don't even know what you call that document in action. So it can be done, and it's a very good idea to do that. When the person then asks for postponement, you're going to have to argue pretty hard. You're going to have to say, listen, court, really, this is what I gave them. Can we just help each other? And now I'm going to pull Ubuntu in. In your application, make a case for your client as the owner of the property with Ubuntu in mind. Tell the court that these are the steps that my client took to try and assist this occupant. This tenant couldn't pay rent. My client really did everything in his power to give him a rent reduction, and still he didn't even pay the reduced rent. Or we utilized the deposit and now there's no money left. I, as the landlord, I have to pay my bond, I have to pay my rates and taxes, I have to pay my levies, whatever. I can't accommodate this person anymore. Guys, stop pleading like cold lawyers and start telling stories in your pleadings. You don't want to simply put facts before a court. It's cold and unpersonal, and nobody wants to listen to your story. Tell the story. Take the court into your confidence. Tell the court that this owner of the property tried everything. Tell the court when the owner is a pensioner and is reliant on his rental income to buy food every month. Tell the court these things. Don't try and leave it for argument, because by the time you get there, we know what's happening these days. The days where you could argue with a judge is a little over now, because they just kick you out of Zoom. Okay, thank you, and they click you out. You can't even moan about it. You just sit behind your laptop and be like, well, that was upsetting. So make sure you plead your full story. All right, so that's the 4-2 notice, and I think it's something very important to be comfortable with. But let's pretend I have a slideshow again. I have so many slideshows open now. I wish you guys could see the other side of my computer right now. All right, so that's the 4-2 notice. I want to talk about defenses, because if you're not prepared for defense, you're not going to know how to deal with that. So something very important on defences is that your occupational right was never cancelled. Now, currently, I'm seeing this defence popping up more than ever before. I think the main reason why this is happening is landlord and tenant made arrangements during full lockdown, and they didn't they didn't do it in writing, they didn't get legal advice to get it done. And the landlord actually now feels like, I've done enough for this tenant now, I just need him out. Now, we know as practitioners, we know that that's not how the law works, but your client might not know that. So all the documentation that your client's done, all the letters, all the DIY plans that they've made while we were safely at home, make sure that you go through that and make sure that the occupational right was actually cancelled properly. What I see often, unfortunately, is that your client, the landlord, the owner of the property, did a few notices and you see that he really tried pretty hard. So he was almost on point, but he missed the mark completely. For instance, he didn't say that he's going to cancel the lease agreement. So he didn't elect a remedy yet. He didn't make it clear what the breach was. So he made a mistake on the letter of demand, but he gave the tenant 20 business days. Now, by the time he gets to you, he doesn't want to start the process over, and you feel bad for your client. Guys, to waste, and I say this in inverted commas, to waste 20 business days in the beginning of an eviction process is the best wasted time you can ever do. Because if you push forward on documentation that you actually know is a little shaky, and that your right of occupation might not have been properly cancelled, I promise you, you're going to end up in court with a dismissal, and then you have to go back to your client and say, oopsie, I had sort of a gut feel I have to rather resend a 20 business day letter. Rather safe than sorry. Really overly cautious when it comes to cancellation of that occupational right. Make sure the words that the right has been cancelled, you are in illegal occupation, you have to vacate. Those words are clearly stated in your cancellation letter, so there's no dispute around the potential existence of an occupational right. Then I have a very fun defense that I've seen a few times in my life, habitatio. Remember habitatio? So for everybody that's not attorneys, I'm sorry, I think I got away with not using too much Latin, but when it comes to defenses, I'm sorry, I have to. Habitatio is a principle where you have a life right. So there's so many other arrangements with the owner of the property that you can use this property and stay there until you die. Usually the right of habitatio must be registered in the deeds office. However, if it's not registered, it's enforceable inter partes, so between the two parties that agree to it. But when it comes to the notice, to the knowledge of a third party, it will even be enforceable on that third party, even if that is not registered in the deeds office. So very important, right? Habitatio obviously gives you a permanent, until you die, right of occupation. Can't evict those people. It's as simple as that. Depending on the story and the arrangement around it, usually habitatio is a very good defense. Luckily, not something you see often, but when you do, you're not going to get that eviction. It is a valid defense, so find a potential other solution for the problem that your client might be in. Les pendens is a defense where there are two pending matters on the same facts and asking for the same relief. Les pendens attorneys, I'm very sorry to say, but we're usually the ones creating our own les pendens. So what happens is your client is with one attorney. He feels the eviction takes too long, which, by the way, all clients feel about every single eviction, regardless of how long it takes. But I suppose every single attorney feels the same way. How long does an eviction take? Too long. That's the answer every time. So what happens is your client gets frustrated with the attorney he's currently with, and he goes to you, and instead of you asking the question about the other attorney, you just commence with proceedings. You might not know about the pending proceedings, so just make sure If there's pending proceedings, guys, luckily lis pendens is a defense to get around very easy. You simply withdraw one of the 2 proceedings and bam, lis pendens is out of the way. But try to not give anybody a gap like that. Then a claim in lien. Claim in lien is actually a defense I see often, but really not a good defense. What this will look like is a tenant might believe that he fixed something in the property, or an occupant for that matter fixed something in the property, and he's using his claim in lien sort of as a right of retention. So usually it's tenants that come up with a list as long as my arm of things they've done in the property, things they've changed, things they've improved, and that's why they're not paying rent, so they can't be evicted. Or they are saying even better, I've paid my rent, but I'm not going to vacate the premises until the landlord reimburses me for the things that I've done to the property. Okay, so claim in lien is a very bad defense. I haven't seen one succeed ever, but I'm quite sure there will be. There would have been. I've never seen one personally on one of my clients. But claim in lien, very important requirement. Usually, your claim in lien is excluded in terms of your lease agreement or your offer to purchase even. Claim in lien is excluded in writing. It can, because it's a common law principle. You can contract out of that in terms of your contract. But also, a claim in lien can only succeed, well, when it's not excluded, but in a situation where the amount that the tenant is claiming is for repairs or alterations that was necessary and urgent without consent of the landlord. Guys, how often does this happen? And only to the value of the repair. So say, for instance, a washer broke. Even I can replace a washer for nothing more than R5. So you can't hold on to your right of occupation for a R5 washer fix. Or maybe you're not, you don't have a fully equipped plumbing toolbox, and you might have to get a plumber out. Okay, lucky, now that problem is a R650 problem. It's not going to give you the right not to occupy the premises for a very long time. So don't get a fright on a claim in lien. Look at it, address it in your replying affidavit, and you should get past that relatively easy. For practitioners acting on behalf of people getting evicted, so defending the matters, try and stay away from a lien. It's not a good defense. It's really not a good defense unless it really is a spectacular defense, but you will know about it. It will be where the property blew down in a hurricane and the person had to basically rebuild the thing. But even that is more undue enrichment than anything else. So if you're defending, try not to go for a lien. Rather, if you know that your client is in illegal occupation, rather try and settle on a date that would be fair for all the parties to vacate, because in fairness, there isn't, except for habitatio, there isn't really a lot of valuable true defenses to an eviction. If your client is the owner of the property and if the tenant is in illegal occupation of the premises, unfortunately, if you act on behalf of the respondent, you're not going to succeed with your defense. You're only going to delay. So rather try and settle those matters. I'm not even just talking because I'm not just saying that because I usually act on behalf of owners of property. It's really the true state of the legal. It's the true legal position in this. Obviously, a very valid defense on an eviction is that the provisions in terms of buy hasn't been followed. So a procedural defense that the process wasn't followed correct, and that is a valid defense, but it is not. It is simply process that's wrong. So you're going to commence something new, and you're anyway going to succeed with your eviction, but that particular eviction will not succeed, and you will have to start something from scratch. So make sure you get the right things done, do it the right way, and it's actually quite simple. So if I quickly go back to the process, we've gone into a lot of detail now on the notice of motion, the founding affidavit. What are we pleading? What are we not pleading? What does the ex parte application look like? What do we do with that? The 4-2 notice you've seen. So I'm just quickly going to take you back very quickly to the flow chart, just so your brain can wrap it all up together again. because that will make a lot more sense to you right now. All right, so what we've done was, we've done the cancellation of the agreement, we've done our notice of motion and our founding affidavit. Once we determine that the matter is going to be unopposed, it is as simple as bringing your ex parte application. Based on your ex parte application, you're going to use the same form that the court authorized in terms of your ex parte application, and you're going to serve by sheriff in the manner that the court gave you a service directive in terms of your ex parte application. Again, there must be at least 14 calendar day gap between service of your notice in terms of section 4.2 and your eviction hearing. It's a very important but very easy actually to get it done. Once you understand the eviction process, once you've done a few, you will see it's almost like baking sourdough bread. I don't know if my analogy helps in any way. But if you've ever done anything new, any new skill is the first few times that you do it, you're like, oh, how do we do this? An eviction is actually a very simple thing, guys. And I think I can say this now after 12 years of doing just evictions. I think if you can fall in love with evictions like I did, where I'm building my entire firm exclusively around evictions, and I've done that, like I just said, for 12 years. All the attorneys in our firm does exclusively evictions. It does turn into a field that you are very comfortable with, and it's actually quite easy. I promise I won't tell your clients it's this easy. The good news is, not good news, but the truth of the matter is, evictions will always be very technical in law. So it will always be one of those parts of law that you're not going to be able to DIY. I can't see that after years and years and years and talking to practitioners and seeing what other attorneys are doing. I mean, I have guys on this webinar today that's my senior by forever, and you guys obviously know a lot more about the law than I do, because I'm only focusing on this very specific small part of the law. But when you, but even for you, you're struggling a little with an eviction here and there and trying to figure out the way you plead around specific things. Your clients will never be able to do an eviction themselves. Please keep in mind that the Rental Housing Tribunal doesn't have jurisdiction to grant eviction orders. And even if your client has like all the right documentation, even if you have the right documentation, which I gave to you, the BAM, there it is, all your pleadings, everything your heart desires, it's right there. It's the way you apply it, the way you use the documentation, that makes you a good practitioner on evictions or not. The skill about an eviction is you need to understand your area, your sheriff, the court that you are practicing in. You need to know whether it's going to be quicker for you to go to the High Court compared to the Magistrate Court. On that conversation, do you go to the High Court or Mag Court? I don't know. It depends which one will be quicker. For SSLR, it's easy. We know which courts are going to be quicker. For instance, I'll give you examples even. If you have to choose between Randburg Magistrate Court and South Gauteng High Court, choose Randburg Mag Court every day of the week. Randburg Mag is much quicker than the High Court. However, if you have to choose between Johannesburg Mag Court and and South Gauteng High Court, please don't even try the Mag Court. You're going to start drinking, and it's not good for our livers. Okay, it's really not. We're already having all the alcohol. Keep the alcohol for the hands right now. Okay, you will get comfortable with the. You will actually get comfortable quite quickly with the way that your evictions are functioning the moment you start doing a few of them in your particular court. So very important that you are aware of this. Very important that you use the right court. That would be the quickest court to approach. So I told you I will tell you something quickly about service by the sheriff. What I'm suggesting currently is because we are struggling with service from the sheriffs, I do recommend that you approach already. If you're in an area currently where you are struggling with the sheriff not being willing to serve, guys, approach the High Court and ask for a substituted service application. I've seen a lot of eviction attorneys lately getting very upset with not getting their documents served, not getting the things done. And I'm thinking, but there's nothing in the court rules that disallows us from bringing a substituted service application to skip the sheriff for all intents and purposes and asking the court for service in an alternative way. Right now, we have good reason to do that. The reason why we haven't done this before is obviously if you went to a court in February and you said, the sheriff doesn't feel like serving my documentation, the court would have said, maybe pay your account and see if the sheriff feels differently about you. I think it's right now it's very different. The sheriffs are overwhelmed in a very big way. And at the same time, I don't think they have the same ability to move around as they usually did. So keep that in mind, approach a court, ask for a substituted service application. And like I said, you can do that over Facebook, over Instagram. I've served so many applications over social media. And I think it's a bit of a surprise because somebody gets like a friend request from you or a message request and they're like, oh yes, okay, I can work with this one. Let's see what she says. I'm saying I'm evicting you, sir. That is what's happening today. So it's a nice little surprise for people over social media. So keep it in mind. It's just a handy little practice tip that I have for you. If there's anything else on the practical side of things, my suggestion is typically just keep on going. Usually I have much better answers and I go into a lot more detail when I'm able to do a physical seminar. And actually I thought about it. I think I'm currently able over the webinar to go into more practical detail because I don't think you guys wanted to attend this webinar to really get into the substantive law of what is the law behind evictions. I can sit here and tell you about case law for days and it's not going to help you at all. So I want to make sure that you have the right documentation, that you know when I say, I have no idea how your court is going to function right now. I'm not saying that because I don't feel like figuring out. I'm saying that because I can see that every day in my own practice. I know that what's happening in Randburg right now and what's happening in Roodepoort, what's happening in Pretoria and in Kempton Park Match, very worlds apart. And we're figuring it out as we go along. But if you have the true principle, if you have your flow chart and you can tick it off as you go along, you will see I have a flow chart for you in the study material as well. It's not as pretty as this one. I wonder if it is in the study. I'll check, but if it's not, I'll send. You know what? I'll do this. I'll send Barbara an email with the 4-2 notice, a separate one, and I'll send you a prettier flow chart, which you can actually print and use. Tick it off, go through the process, and make sure you have the right documents. Remember, to recap before we go to questions, eviction is very simple. You need to prove two things. You need to prove ownership, and you need to prove illegal occupation. That's it. You need to bring to the court's attention everything required from PI. So you need to bring to the court's attention the personal circumstances of the illegal occupant. And then if you go to the actual eviction, you only have three things. You sit with your main application. In your main application, you're asking for eviction and costs. Then you have your notice in terms of section 4, your ex parte application, which authorize your notice in terms of section 4.2, and you're asking for a service directive. On your ex parte application, make sure in your prayers to your ex parte application, you don't ask for authorization of the form and content of the 4.2 notice. Only ask for authorization of the form. Why not form and content? If your matter gets postponed, and you have to re-enroll the matter, your content includes your court date. And then you're going to have to bring a new ex parte application. If you only ask for authorization of form and not content, and you need to postpone the matter, you're simply going to do that by a notice of set out. So nothing funny, nothing weird, so make sure you don't accidentally ask for form and content, just form. Then you ask for your service directive. If you need a weird service directive, bring an affidavit with your ex parte application to ask the court for a service directive that's going to work in that situation. And then you have your 4-2 notice. Your 4-2 notice is your spoon feeding of the respondent. The purpose of the 4-2 is to make sure that the respondent knows that he has the right to attend to court, that he knows he has the right to defend the matter, and that he knows he has the right to obtain some or the other form of legal assistance through legal aid, the law clinics, things like that. Make sure you help them as much as you can, and make sure you plead on behalf of the landlord or the owner of the property in such a way that you plead Ubuntu in. Make the court realize that the owner of the property is not the mean, scary guy with the deep pockets, but he's potentially also suffering damages. Tell the court how much the owner of the property tried to assist the illegal occupant. The last thing you want to do is to create the perception in the court's eyes that the owner of the property is the mean landlord, and he's the guy with the attorney and the legal representation, and the court has to step in to protect the illegal occupant as the underdog. Yes, the court has to protect the illegal occupant, but PI is there to do that. So bring to the court's attention why the owner needs the court's assistance. Plead that. If you are acting on behalf of the respondent, bring Ubuntu in as hard as you would with the landlord. Tell the court that this landlord didn't even place my tenant on terms. This landlord didn't even try to help my client. Plead that. So instead of trying to bring all the weird defenses on claims in yen because your client replaced the washer somewhere, rather do something bigger, do something real, and tell the court what is happening. But in those situations, always when you act on behalf of a respondent, my advice is always try to settle, and then when the landlord or the owner of the property doesn't even want to listen to the proposals from the tenant, even more so, gives you a very strong right, obviously, to show the court that the tenant now the illegal occupant needs the protection from the court. So on that high note, I'm actually 8 minutes later. I'm having way too much fun with you guys today. 8 minutes later than I want to be, but let's see what we can do. Okay, I'm going to open up for questions again. Same as yesterday. I think I was happy that I got so many questions from you guys. It is sad, I must say, I missed the coffee breaks and the conversations we can have during coffee breaks and a seminar or lunch. But I think the email plan is a good idea as well. If you have, I want to invite you to again do that. You're welcome to mail me. Unfortunately, the rest of you won't get the answers, but you are always welcome. Pop me a mail. Like I said, most of the webinars and stuff that I have on SSLR's YouTube channel, I think it would be quite valuable for most of you practitioners, agents, whoever. Guys, please don't stress about my whatever there. If you have a client that you feel one of the webinars that are, or the recordings I have on YouTube is going to answer your client's question, please send them the links. I promise I am there to give free quality information to the industry side of people that needs to understand how things work. You are really welcome to use my YouTube stuff as far as and wide as you need to do it. And if you have any questions, you are always more than welcome to give me a shout and brainstorm or whatever. But on that high note, I'm going to open for questions. I think yesterday it worked pretty well. I just want to check the questions here on the side, if there's anything. Okay, thank you, Chris. I think I'm with you. I will make sure that you get the right 4-2 notice the correct one, and I'll make sure it's in Word document, in Word form, because you don't want to sit and retype stuff. The examples, precedents that I have in the documentation is pretty handy. You can retype that, but I don't think it's really rocket science there to do that. You will see also on LexisNexis, on the practical guide side, I think this is probably handy right now. On the practical guides of LexisNexis, I'm the author for rentals and evictions. So there's some precedents and some practical guidance on that side as well, if you get stuck in any way. But let's do this again for questions. Maybe we can raise hands, or you can just unmute your mic, and again, let's see who's quickest on the draw. Anything? No, you guys are just being polite now.
Hi, Selma. Martin here. I just have a question about the recordings. Are we going to be provided with them or not? Because I had some technical issues as well, and it would be great if we could rewatch the webinar at our leisure.
Martin, unfortunately, since I'm not with LSSA, I can't answer the question, but I'll make sure to talk to LSSA when it comes to the recording and the 4.2 and everything. But I will definitely make sure that you that Barbara gets in contact with you to just clarify that. There's actually been a few other people that's mentioned that as well, so I'm quite sure the recording will be made available.
All right. Thank you so much.
Pleasure. Anything else?
Hi, Sona. Just have a question about locus standi. You mentioned that that the person bringing the application must be the owner of the property. Does that mean that if an owner's spouse who's married out of a community of property can't bring an application for eviction?
Yes. Remember the parties married out of community of property, that property has nothing to do with the other one. What I would like to see in a situation like that is the reason. My example was also the wife. I don't know why, but for some reason, property investors always use the spouse, be it the husband or the wife, to do the practical management of the thing. So I've seen that as well. What I suggest there is the spouse can be a party, and the spouse can potentially attest to the affidavit with a confirmatory affidavit then from the owner of the property. But the applicant must be the owner of the property or the person in charge. Happy? Sign language really became a thing over the past 3 months over Zoom. Like, we can have like full, we all understand what this means. And we know that means I can't hear you, I can't hear you. Or if you, there's like these little weird webinar things that we now understand. All right.
Chris Kotze here.
Yes.
I want to be a bit opportunistic, if you don't mind. And while I have you as a captured audience, just ask you a question on a commercial lease, if it's fine with you. I've got a client whose previous MD retired in March of this year. So he co-owned a property which the client company rents, and just prior to him retiring, he signed a lease on behalf of the client company. That was in December 2018 already, and the lease commenced on January 2019. He only retired in March of this year. So he signed a lease for a period of 5 years, but he did not follow any of the requirements in the Companies Act with regard to directors' interest in contracts. He also did not follow the provisions of the Memorandum of Incorporation, which require him to obtain board approval before binding the company to large expenses. So in the meantime, the client has done some market research and found that the rental is close to double the market related rental for the property. Now, they have engage with the landlords in attempt to align the rental to market-related rental, but they're not interested in doing this. I'm a bit worried that that they will say that the client has rectified and accepted the shortcomings of the director's actions because of the time that has elapsed since they did this. So I'm not 100% sure how one will approach this situation. Do you have any suggestions for me?
Always. I always have suggestions. Whether I'm right or wrong, I can't commit to a vision, but let's see. I must say my head that immediately moves away from the lease agreement and the rental side of things. And my head wants to jump into the Turquoise rule more than anything else. So if my head wants to jump towards the Turquoise rule, then I must say I feel like that might be the answer. Simply because that's not something that happens in my head very often. So I'm immediately seeing that Turquoise rule commercial law exam paper about with the example of the director buying a racehorse. Why always a racehorse? Remember, that was the example always for the Turquoise rule. I must say, I think you're going to more resolve the problem through the Companies Act than through a rental thing, because the lease agreement side of things, there's no obligation ever that your lease has to be in line with, your rental has to be in line with the market. It doesn't have to be market related. It's allowed to be crazy because we have the caveat subscriptor rule, obviously. So if you agree, parties are free to contract on the weirdest things. I think your issue, if I understand correctly, will be more on this MD didn't have the right and he wasn't authorized correctly to do this. And this was not just outside of the scope of the business, but it was in a direct way that's going to negatively impact the potential sustainability and survival of the other company. Am I right, or am I being a little overdramatic?
No, you're quite correct. He enriched himself at the expense of the company.
Exactly. And I think based on that, but not from a rental side, to be honest, there's nothing you can do about it. From a company law side, I would go for a board meeting and get the directors and shareholders there to agree to an investigation into the whole thing and potentially set that aside. Obviously, the tenant then does have the right to call on estoppel to stop them from doing something funny, but then, I mean, the company would be able to utilize estoppel when the tenant entered into the agreement. But I think even estoppel here isn't going to be good enough to say. I think if the company can show that the actions of the director wasn't in line with the MOI and with the Companies Act, you would be able to set that transaction aside. But that is a company law thing now and not a property thing. So don't judge me if I'm a little off on what they can and can't do. But luckily, I've seen a thing or two in company law as well.
Okay, great. Thanks a lot for your.
You think that can work?
Yeah, no, I do think. I also thought immediately about the Turquoise rule. I don't think they're gonna be able to rely on that because obviously the director knew exactly that he didn't have the authorization and so forth. But I also believe that in terms of the lease, there's not much to do. The remedy might be in the Companies Act there.
Yes.
Okay.
Good luck
with
with
that.
Pleasure.
Thank you.
Pleasure. Any other opportunistic questions? I like the opportunistic questions. Marlies. Oh, jy's gemute. Now I want to do the classic Zoom meeting. Desi.
So I just have a question regarding employment housing agreements. So obviously PI will then, because it's people living there, PI will be applicable.
Yes.
But I don't think the CPA will how will you cancel? Can you cancel immediately?
So not the CPA, unfortunately, but my most hated part of the law, labor law. So labor law is going to be relevant. So your employment contract is going to be relevant. And I just openly, while I'm recording myself, said I hate labor law. I'm sorry. But your employment contract will deal with that. Say, for instance, the right to occupy stems from the employment contract. Cancellation will then be relevant to that. So I've seen a few of these cases where the person gets fired or dismissed or whatever, and they go to the CCMA. And so the entire cancellation of the employment contract is up in the air and in dispute. Your eviction is going to have to pending the outcome of the decision from the CCMA. If they don't go to the CCMA and you are lucky enough to get the problem from your client before they started doing things, just make sure that you cancel the employment contract together with the right of occupation in terms of the employment contract. Okay. So it's going to show that's a bit of a hard knock on a person. It's one thing to get fired, but to get fired and kicked out at one. Sure, 2020 is not a good year for a lot of people.
Okay, so when you do cancellation of employment, also mention cancellation of, and then it's 2 flies with 1 hit.
Exactly. I would definitely do a separate notice on top of that, which I will call a notice to vacate. There isn't such thing in our law, but tenants, people that it doesn't have to be a tenant per se, but they don't really, people don't read. So even if you do put it in the letter of dismissal, and you say you're getting dismissed or the company is closing or whatever the case might be, and accordingly you will no longer be allowed to stay here, it could very well accidentally also happen that they don't read that. So even though you said this big that you also need to vacate, they're not going to see that. So just for safety's sake, do a separate notice and be reasonable on the time to vacate. Yeah. Even though the dismissal might be immediate, give them a month or so to vacate the premises before you commence eviction.
Okay, Ubuntu. Yeah, okay, thank you.
Pleasure, good luck. Righty, I had another hand up earlier. Who was that? Okay, there's a question. Silna, could we get an example of a MURA or cancellation letter? And is TPN updated and correct? Okay, so unfortunately, I'm not going to give an example of a letter of demand simply because correspondence, I'm always very reluctant to give precedence on correspondence, simply because I have to base it on a lease agreement. You have to read that. So unfortunately, I'm not giving examples, but the TPN letter of demand and cancellation letter, I know the drafting attorney pretty well. I am stuck in her body 24 hours a day. So I update the TPN letter of demand and cancellation letter on a regular basis. I've done an update about a year ago. I haven't had, it wasn't necessary to update since then. I'm definitely a fan of the TPN letter of demand and cancellation letter. Never need to resend that unless the person who sent it had the time periods wrong. But definitely, if you get TPN letters, you can use it and you can commence your eviction based on that. I've done a million evictions on them. And on there's a few other systems that does automated letters of demand through PayProp. Kuchlenberg does PayProp's letter of demand. Good friends of the guys from Kuchlenberg, happy with that letter of demand. So there are a few system generated letters. Not all of them are created equal. I must say there's quite a few that I unfortunately believe we have to resend, and you can't proceed with eviction on them. But read the content. The rules are pretty simple. If it clearly sets out what the breach was, if it clearly sets out how the breach should be remedied, and it clearly sets out that if the breach is not remedied in full within a specific time period, the lease agreement will be cancelled, then I'm happy with that. If it comes with weird shenanigans like, after 7 days, this is going to happen, but then after 3 more days on that is going to happen, and then that's, nobody understands. If us as lawyers read a letter and we like, huh, what? it's not going to suffice. Must be clear, must be simple. You've done this, you shouldn't have. You need to fix it like this. If you don't, this is going to happen. That's what a Mura letter should look like. If it's complicated, if you start numbering your paragraphs and you are at paragraph number 5, you've missed a mark. You need to keep it simple, clear. I believe in litigation, in anything, in life in general, if you can't make your point in 1 page, you're probably missing the mark. And I say that for everything except for a lease agreement. If you keep a lease agreement short, you're probably missing much more than the mark. Correspondence, when it comes to corresponding with somebody that's not a lawyer, you keep it simple and you don't try to overcorrect it. My moeder, Johan from Paperop says hello. 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 Johan de Boot. Ach, my moeder say hello. Well, this is how we know the joys about the property industry. It's this small. Does a subtenant have any rights over the landlord? Okay, I'm struggling a little with that question. I think the question is, what are subtenants' rights? I think it's a good question, so let me address that. A subtenant's rights stem from his agreement with the tenant. The tenant is the person in charge, because remember, if the tenant, the initial tenant, has a right to allow somebody to occupy through and under him in terms of a sublease, that tenant effectively becomes the subtenant's landlord, if that makes any sense. So the subtenant has to comply with the arrangement he has with the tenant. If he doesn't, the tenant does have the right to evict the subtenant. The subtenant is renting through the tenant that has the right to do that, so he's the person in charge. The subtenant's rights towards the landlord is pretty limited because his relationship with the landlord is limited. However, if the sublease is disallowed in terms of the lease agreement, the landlord still has the right to evict the tenant and the subtenant, because the landlord is evicting the tenant and anybody holding rights through and under the tenant, if that makes sense. So the landlord has a way of evicting the subtenant as well, but the subtenant doesn't have any rights to demand any performance from the landlord because there's no relationship between the landlord and the tenant. It's a pleasure. Okay, one more question, and then I probably have to get you guys back to writing fees, right? What should I do? Here's a code. Oh, this is a very good question. What do we do currently if the tenants are not if the municipality is not complying with the provisions to provide the report to the court to show what's the situation on alternative accommodation? Guys, this is a problem, a very big problem currently, because all the municipalities are saying, they've always said, we don't have alternative accommodation and we all just move around it. Currently, the municipalities are saying, we're not even issuing reports. It's a very real problem. My suggestion on that is potentially an interlocutory application compelling the municipality to either deliver that report or to engage with the occupants. If it's necessary, always get an order like that on the side. My recommendation is always to have the municipality as a respondent, so you have that potential situation of jumping in there and saying, but listen, I need an alternative relief against the municipality at this stage. So if it's necessary, ask for that relief. But the truth is, most of our courts currently appreciate that the municipalities aren't delivering the reports. Address it in your papers. Do a supplementary affidavit and say, the municipality is not providing this report. However, this particular illegal occupant isn't going to be left homeless and destitute, isn't going to be left in a position where the municipality will have to provide accommodation. So please grant me my order, because the municipality isn't going to be required anyway in this particular case to provide alternative accommodation. We're going to turn into extremely creative attorneys, guys. This is sort of where we are now, so we have to work around with what we have. Okay, another opportunistic question. She said it's opportunistic. I'm not saying it. That is the question. I have an opportunistic question, quite specific, and I don't mind waiting until everyone is left. Cool, we're going to do that. I'll hang out. Can a parent evict his own children? Oh, Yella. I love these questions. This happens much in the township, unfortunately, when the children doesn't leave. Yes, a parent can evict a child can evict a parent. Siblings can evict each other. I've done these evictions multiple times. As long as you can show that there's a reason why the kids can't stay there anymore. Obviously, guys, we're not talking about minor children. You can't evict your minor children as a parent. You sort of have this weird responsibility towards your child. So you're not allowed to evict your children if they are minor children, but if they are adults, and you said to them now a year ago, my bookie, really, you're gonna have to start, doing your own thing here. The Afrikaans term, jou eie potjie krap, comes to mind now. You have to start doing your own thing. We can't have you living until you're 40. You need to go. You would be able to. You're just gonna have to plead quite impressively around the reason why they are now suddenly in illegal occupation. But make sure you do enough correspondence in advance. Give them enough time to vacate and try to stay away from family litigation, simply because I have done a lot of family litigation like this, not family law, like evicting spouses and neighbors and family members and stuff. I promise you, unless you try and get your correspondence in line, you are very, very quickly going to be the bad guy. And you don't want to be that, so make sure you do your best to resolve on rather on correspondence than anything else. Then I have a last one, and then I will set everybody free except for the person I still have an arrangement with. Unless you guys want to stay, you're more than welcome. I'm going to stop the recording after this question, and you're welcome to stay if you want to listen to the conversation. I still also have a specific question. Yes, Monica, we are there. Alrighty, guys, so what I'm going to do is I'm going to stop the recording and then still stay on. Thank you so much for joining me. It was really fun spending the past 2 days with you. Like I said, if you have any questions in future, please feel free to contact me. I'm really one of those weird, helpful colleagues. So you're welcome to contact me in future. And thank you so much. It was so much fun spending the past 2 days with you. Stay safe and wash your hands.
Hello.